Good afternoon. Am I audible? I hope I am audible to all the students.
Yes, sir.
Yeah. Okay. So, good afternoon. I welcome on behalf of Marathwada Mitramandal Shankarrao Chavan Law College Diploma Department in this two-day workshop on the forensic science. I welcome all the participants and the resource person for this particular workshop, Mr. Phaneendar B.N. sir. So before starting with the lecture, I will like to introduce the chief guest for this particular workshop on the forensic science. The chief guest for the workshop on the forensic science is Phaneendar B.N. sir. He is from Bangalore and he is the court commissioned forensic expert and the advocate. And he has completed his MSc, LLB, and the LLM in the torts and the crimes, and MSc from the cyber security. He has completed his PG diploma in the forensic documents and the fingerprint examination as well. And right now he is working as an legal expert in the evidence field. He is also certified from the American Institute of the Applied Sciences as well from USA. Also, he is certified PDD expert TVC South Africa. He is the member of International Association of the Identification, and he is the trained personnel in the data protection as well. He has the professional experience of over 13 years and he has examined over 5,500 cases, including handwriting, signatures, ink, papers, rubber stamps, security documents, then fingerprints, then accidents and the fire examination, polygraph test, and the digital examination of the evidences. Also, he deposed in over 500 plus cases as the forensic expert and have cross-examined the various forensic experts as an advocate. He has been appointed as the court commission in the various cases by law courts and the forensic reports resulting in the several convictions in the criminal cases, reports appreciated, upheld by the various civil, criminal, consumer courts and the high courts as well. Also, he is the chairman and the managing trustee of the Clue for Evidence Foundation, which is the NGO for the investigation and the legal support. He's the advisor for the International Association of the Scientists and the Researchers. Also, he's the member of the Board of the Studies and Board of Examiners for the Department of the Forensic Science. He has been awarded with the award name titled as the Dedicated Teacher, which is the award given by for his excellency, and award given by Shri Hansraj Bharadwaj, who is the governor of the state of Karnataka. Also, he has been the resource person for academic institutions for designing the various training and the certificates program regarding the forensic science. He has been felicitated and recognized by various organizations for continuous contributions, especially in the victim support and upholding the truth in the investigations. He has been the professional membership. He has been the professional member of the various institutions, that may be International Association of the Document Examiners USA, International Association for the Identification USA. He is the editorial member of IASR New Delhi. He is the member of the International Association for the Identification as well. He is the life member of Karnataka State Rifle Association as well. As far as his research work is concerned, he has published various research papers in the international and the national conferences related to the forensics and law. He has won the best paper awards in few national conferences as well, and he has been guiding for several students to complete their academic projects regarding this particular subject. He has been invited for the various guest lectures and the workshops by the Karnataka Police Academy, Mysuru law departments of the several universities, various bar associations across India. Also, he has conducted the occasional trainings for the police officers as well and the various insurance companies. He has been the speaker for the topics which specifically include the forensics in the criminal investigations, role of the forensic document experts in the criminal investigations, cross-examination techniques, documentary and the digital evidences, electronic evidences and their admissibility, lie detection and the interrogation techniques, signature forgery examination, cyber laws, cyber crimes and the techno-legal topics, and many other customized topics related to the law, forensic, and the investigation. I welcome you, Phaneendar sir, in this 2-day workshop on the forensic science, and I would like to request you to start with the session. And the topic for the first session, that is the forensic science and the criminal investigation. So I would like to request you, Phaneendar sir, to start with the session. Thank you.
Thank you. Thanks for your openness in having a workshop as well as introduction about me. However, participants, I also welcome you all for this session. I believe you all from the law background and legal professionals or future legal professionals. It's my pleasure and privilege to share the topic, which is the morning hour we're discussing about the recent trends in forensic science, especially for the investigations. However, the topic is so defined that in the first hour, we'll discuss about the general approach of the forensic science and investigations. The second hour, we'll be discussing about the specific topic, which is the documentary evidence in the legal process, as well as the third session will be on digital evidences in the legal process. While it's not new today that everybody are so exposed to the crime news, the documentaries and the movies which are based on the real-time crimes. And a lot of exposure has been given on the forensics part of it. It's not it's not a very new subject as a forensic is concerned, but what is new or what is not yet discussed is a real-time approach of the forensics, because in movies, the way they project the forensic science is that when you approach a forensic expert, your case would definitely be solved, no matter what the background is. That is the impression what they try to give, especially in the movies and the online portals. But the reality of the forensic science is what we first discussed in our discussion, where the question is that our legal system, our present laws, which we follow even today, does this support for effective application of the forensic science? And what is the scope of the forensic science is what we'll be discussing in our first topic. So before I proceed ahead, let us first understand what is forensics. So let me ask the participants, how do you want to define forensics as? Can anybody wish to volunteer and answer my question? What is forensics according to you? Or what have you known about the forensics? Okay, let me call upon the participants. Ankita Shinde. Pratik, can you please confirm if the participants can unmute their microphone? Is the option open for them?
Yes, they can unmute themselves.
Participants, please be noted. I'll be asking you to be actively participating by answering my questions as well. So Ankita, can you please unmute your microphone and answer my question? What, according to you, is forensics and how do you see forensic science as? Amruta?
Yes, participants, I would like to tell all the participants to answer the questions. Yeah.
Sonia, go ahead.
Sonia.
So, sir, forensic, it cannot be defined, but yes, the meaning could be it's a way or a method to investigate the crime, a kind of scientific method, probably.
Scientific way of investigating a crime. Yeah, but how is forensics significant to the legal system then? If it is only to be used for the investigation purpose, why are we discussing that in our law session today? However, forensics, as a textbook explanation is concerned, is that branch of science, or that is the approach, a logical approach, which is used for investigations, and especially as required by the legal process, that is the courts. Because court will believe anything which is logical, anything which has a systematic way of approach. That's what the court will actually ask for. So for this reason, the forensics is the branch of science which is required by the legal process. However, let me define the forensics in the way where it can be understood by even a layman. Numeric 4 and numeric 6 makes 4 and 6. So the total of this 4 and 6 is 10. In binary system, 1 is always given as a truth value and 0 is always given as a false value. I mean, that is in the electronic section. It's because it works on binaries. If the result is taken as 1, that is deemed to be a truth value, and it is 0 is considered to be a false value. So as far as the forensic is concerned, the scope of forensics is to ascertain if the given claim is true or the given claim is false. When I say given claim, as an advocate or as a police officer, anybody can bring in any kind of claim, which means suppose there is a blood sample in the scene of crime. They go get the blood sample and they claim that this blood sample belongs to a suspect. And by taking the blood sample suspect, we are going to confirm, yes, if the claim is true or your claim is actually false. That is something which the forensics will deal with. So like this, the scope of forensics is to ascertain the claim being truth or the claim being false by conducting necessary and logical examination as required by the court of law. But when you ask me, what is the further understanding about the scope of forensics? Participants on the screen, and for all those who are using the computer screen in front of them, and not the mobile screen. Okay, if you're using a computer screen, can you quickly tell me which of these two lines, line AE or EC, which of these two lines appear to be lengthier? You can use the chat box. The question is, which of these two lines are lengthier?
The AE.
AE appears to be lengthier. Okay, so is it the answer of everyone, or if there is any change in the answer? I believe most of you feel that line AE is actually lengthier than compared to line EC. Yet, I'll go with the next understanding. So what I recommend is that you keep your mobile screen away, keep your phone still. You can see a black dot on the screen and go back at least 3 feet. Go back 3 feet from the place where you're sitting. Keep the mobile phone and take a 3 step back. Now, open your arms and use your index finger. Focus on the black dot. And everybody has to do this so that you understand what I'm trying to tell you. Okay? So keep your screen and go 3 steps back. Open your arm. Focus on the black dot. Now close your left eye. Focus on the black dot and close your left eye. Hold your hand still. Now open your left eye and close your right eye. Are you still focusing on the black dot?
No, sir.
No. Sonia, do you think the black dot is moving?
No, sir.
So can you explain why is that you're not able to see the dot at the same place? Any answers from your side?
That's as the moment I actually opened my left eyes and closed my, it somewhat, I felt that it shifted, but it did not. So it's the way I saw in the direction which I saw, it could be because of that.
The only understanding with this activity is that our eyes can cheat us. Whatever we see can't just be believed. The scope of forensics is that defines whatever you see on a prima facie. You cannot just believe in that. This forensics is to go deep about what you see and to give a logical conclusion as to why you are able to see like this only. That is the scope of forensics. Now, coming back to the previous question, line AE and line EC. Actually speaking, line EC is lengthier than the line AE. If somebody has any kind of measuring device, you can just put it on your screen and to understand this. And it might have very slight variation on the mobile screen because of the screen size. But if you're using a laptop, okay, you can be able to definitely understand the line AE or EC, which of these two lines is lengthier. Okay, factually, line EC is lengthier, but line AE appears to be lengthier just the way you see at it. Okay, so this actually makes us understand the forensics and its application in the investigation, where forensics is not just what we see, but forensics is all about what we see and which is to be further tested. Why is it seen like this only? That is what the forensics is. There are various branches of forensics. We have almost every science studies, every stream of science, including in the recent days, not just science, even the accounting, even the linguistics, that is where it's supposed to be an art subject. Okay, we have forensic linguistics. So these are a few branches of forensics. It includes medical forensics, toxicology, biology, chemistry, mobile devices and computer devices, which talks about multimedia, cyber forensics, document handwriting, okay, fingerprints. So in the impression analysis itself, you can understand fingerprints, footprints, tire prints, lip prints, bite marks, all these things are the evidences. So next we discuss about the fire, hands-on, ballistics, which comes in the case of the firearms, physics. Physics, we use it for reconstruction of the accidents, fall of height analysis. Okay, all these things, okay, are used for the investigation aspect. So next is wildlife. Wildlife forensics is a separate branch of study. Entomology. Entomology is used to understand what insects are present in a scene of crime, and to understand what insect is present. There is a theory. If this insect of this size is present in a scene of crime, the dead body is at least this much old. That is about, by studying the presence of the insects and its size and its, the cycle of the insect, one can able to say how old is the dead body. So environmental forensics. So all these things are the branches of forensics, which also includes archaeology, forensic archaeology. There is always a dispute about the Taj Mahal. All right, was there a Shiva temple or a temple before Taj Mahal was built? And this is the question. Only Archaeological Department, Archaeological Survey of India, ASI, which also played a very critical role in Ayodhya case, Ayodhya and Babri Masjid case. So Archaeological Survey of India is a separate department, but archaeology is a stream of study. Okay, odontology, psychology, forensic accounting, audit, are the recent trends of the forensic sciences. And most of these topics here, as law students, you all know, in various cases, you would have seen movies, you would have known by the case laws, especially like case like Arushi's case. So you know how the forensics samples are discussed. But I also believe there are a few topics in this slide which you might not have even dealt with, or you don't know that even this has a forensic significance. My next question to you is that Does our law system, does our present law system limit the use of forensics? Before I discuss about this, how many of you are aware with the facts of Arushi's case? How many of you have watched the movie Talwar? None of you have watched it?
Sir, I have watched it.
Okay, can you please give me a brief of the facts of Arushi's case, specific to the evidences in the case? What were the evidences found in Arushi's case?
So basically, it was like the murder happened, and there were four people inside the house: the servant, the victim, and the parents of the victim. There were blood stains. But then there was no fingerprints other than those people. So this was which I could remember.
But with the present evidences, could anyone conclusively say who is the murderer?
No, sir.
Why? When we discuss this question as to why, we then derive our answer. Because in spite of best of the best evidences, the court of law looks at these evidences in a complete different way. Let me read out the CRPC provisions. I believe you all have already studied CRPC provisions, and please underline the specific section which defines the scope of words, section 293 of CRPC, where any document purporting to be a report under the hand of a government scientific expert. So this section specifically applies for government scientific experts, FSL experts of the state or the central. Government scientific expert to whom this section applies, upon any matter of thing duly submitted to him for examination or analysis, and report in this course of any proceeding under this code may be used as evidence in an inquiry. See, here the underline or the specific term to be understood is about may be used as evidence. Can somebody tell me why is it not used shall be used? We all from the law background, you definitely understand the purpose of using the word may be used, or why is it not shall be used? What it is, what do you mean by it may be used? What do you understand from this? Himanshi Srivastava?
So when we say maybe used, so maybe it's not a compulsion or mandatory on the court to use it. Whereas shall is mandatory provision. Whereas maybe it's depend upon the fact of each cases. The court may take a cognizance of the particular not cognizance but appreciate the evidence in that particular case.
Don't you think when the forensic opinions are given, court must rely upon that particular opinion? Because here it says it may be. When we say maybe, it also implies may not be. It can be, cannot be, maybe, may not be, isn't it? So that has the same validity. But why is the purpose they have used may be used? So here we are now discussing about the purpose of using these words. The lawmakers were not so immature to use this kind of words. In spite of we knowing that they were so matured while creating all these laws, why is that they have used may be used? That's a very big question. So what do you think? This is where it says court is the expert of experts. When you have seen the senior experts, I mean senior advocates going before the court, usually mention these words. Court is an expert of experts, which means the court has got the discretionary powers, whether to use such report or consider such report as evidence or even not to consider such opinions or the reports as evidence in the particular case. If that opinion is considered to be relevant, then they'll use it. Otherwise, it is not compulsory that the court have to use that report as an evidence. So the report, whether if it is to be used as evidence or not, is what this section applies. Okay? When we are discussing about this, one important case law, which is to be discussed, noted, and I see as a person coming from forensic science background, I see this case was a kind of disaster. I'll tell you why. Respecting the provisions and the judgment of Supreme Court, there are a lot of lapses in the same judgment, and it is always believed courts deliver judgment but not justice. I do not mean to offend the Supreme Court judgment, but let me give us facts of the case, and then we shall discuss about the provisions of our legal system and how it was considered before the court. This is where I was discussing about the provisions of 293 CRPC. How many of you are aware of this case law? Dhananjay Chatterjee versus State of West Bengal. Anyone who is aware of this in this session? No. Okay. This is a very infamous case where Dhananjay Chatterjee was a security guard of an apartment. He happened to tease a girl who resides in the apartment who was a school girl, 16-year-old. When she used to go to the school, coming back from the school, so he used to tease her. She happened to complain this to her father, and the father happened to complain this to the security officer, who in turn transferred this security guard to a different apartment. But the next day after transfer, in spite of being transferred, this guy does not go to the new apartment, but it comes to the same apartment where this girl used to reside. On this day, the girl had an exam, some exam in her school. She came back from the school. By around 2 o'clock, she had her lunch. She slept at 2 o'clock. And this day was a Thursday. Her mother had a very predictable and consistent practice of visiting Baba Mandir on every Thursdays. This was Thursday, and she had to go to the temple on that particular day. And it's a very predictable time, fixed time. She goes by around 5 o'clock, comes back around 5:20. Very, very predictable time. So on this day, the mother goes at 5 o'clock for the temple. And when she goes out of the apartment to the temple, this security guard happens to go to the first floor where this girl's residence was there. And when he was in the first floor, suddenly the security officer comes to the location. So other security guard who was present in that premises also mentions that Dhananjay is in this apartment only. He has not gone to any other apartment. So security officer calls Mr. Dhananjay, hey Dhananjay, kahan pe ho, bahar aa jao. So he peeps from the first floor, okay, and he says, okay, I'm coming. He comes down, and he doesn't speak anything. He goes to his house. He doesn't stay over there. He just rushes back to his house. By now, the girl's mother comes to the apartment and she knocks the door. Door is locked. The girl is not opening the door. Because the neighbors also believed that the girl came back from the examination. There could be a possibility of the girl not doing well in the exam, and she would have committed for suicide. They already had called the doctor, and some people also broke open the door. When the door was open, the girl was lying in a pool of blood. Mother tries to pick the girl, and by the time the doctor comes over there and declares the girl being dead. Now tell me, who is the criminal in this case? Who is the person? And this case was rape and murder of a minor girl. My question to you is that, who is the murderer? Please answer. Yes,
it is predictable that the watchman is the murderer.
Why do you think so?
Because he was at the spot of the murder at the given time. Because that makes a very strong evidence that he could have been murdered the girl.
Okay. The circumstances of the case indicate that this guy has more probability of committing the crime. Him, everything was fine. So just like the way you are looking at the whole case, police were looking at the same case very similarly. He might have a grudge that the girl complained against him. So everything was fine. But in this judgment, in the judgment, very, very importantly, there is a clear-cut Supreme Court judgment I'm talking about. There's a specific paragraph in which the judge mentions the assistant chemical examiner of the state has given his opinion that there was a semen which was taken from the girl's pubic hair because it was a case of rape and murder. The semen was present. And for all practical reasons, semen is supposed to be the biological fluid of a male. So when semen was present and when this was examined, and the assistant chemical examiner of state of West Bengal has clearly mentioned in his report that this semen does not belong to the accused, who is Dhananjay. Now tell me, who is the murderer? Vaishnavi, you have anything to add to this?
No, sir.
No. See, this is very unfortunate. That's why I mentioned that in spite of the report of the state of West Bengal laboratory by the assistant chemical examiner, who mentioned that the semen did not belong to the security guard, that is Dhananjay. In spite of this, the court awarded the death penalty to this person. This is that's why I mentioned this is an unfortunate case. Why? Because this also demonstrates and defines how Section 293 CRPC can be may be considered as an evidence, because this medical report, the medical examiner's report, alone shows that this person was not the perpetrator or the criminal. But rest, the entire facts of the case shows that this is the same person who would have committed the crime. So circumstantial evidence had a better role to play than the medical evidence in this case. So in spite of best of the best forensic opinions, whatever we do sitting in our laboratory, that may not or may be considered by the court as per the discretion of the presiding officer. And it is not compulsory that it must be, always be considered by the court of law. So that's what we have to understand from this case law. Fine. While we are, while you already know about some branches of forensics. Let me
excuse me, sir. Sorry
Yes,
to interrupt.
Yeah.
I just want to ask the real accused was not held in that case.
See, as per the Supreme Court judgment, this is a guy who was said to be accused. But when you ask me, based on the evidences available in this case, because the semen did not belong to him, so who have raped and murdered the girl is actually unknown. Okay, so and it is a challenging situation for the state also. When this guy is not the criminal, who else is the criminal? Instead of finding the actual criminal, it seems like they have just framed a person in this particular case. Because it's also true that this guy was around 31 years when he was convicted, and he did not have any kind of bad record, what is a bad case history of police records. He was clean to that extent. He was survived by his wife. Okay, so all the facts, okay, are also intact. Okay, there is not a single case against him so far. So everything is fine. But in spite of that, okay, this guy was said to be the accused and he was convicted. In spite of medical evidence saying the semen did not belong to him. Did I answer your question?
Yeah, thank you, sir.
Yes, all right. Fine. Now, moving forward, so the question before us is that what are all the recent trends in the forensic investigations which would be used in your legal profession very soon? Because earlier days or the conventional practices in the forensic science is that, medical forensics, post-mortem toxicology, documents, fingerprint examination, and maybe few of you also know about the digital forensics. Everything is fine, but is it all, or do we have any other branches of forensics which is used for your real-time investigations, and which might also be used for your legal proceedings tomorrow? That is a question. So in such a question, I have highlighted a few important topics, which is the fire investigations, vehicle key investigations, vehicle fire investigations, accident investigations, and digital investigations. I'll just give some orientation to this because these are not so well explored branches of forensics, especially for the litigation cases. Okay, when we discuss about the insurance cases, insurance claims, insurance is a different industry altogether. So when we discuss about the insurance cases, all these things are very, very significant and very, very important. Okay, I'm just showing you a scene of fire where suppose if there is a claim that this particular go down was said to be insured. This was insured for X amount of money, and because of fire, the goods were lost, goods were burnt, and there is a claim for the insurance. So should the insurance company process this claim or not? That is a question. And insurance company will only process the claim only when the intentional fire is overruled, negligent fire is also overruled. That is when the insurance can be claimed. See, for example, if you are driving your vehicle, if the vehicle meets up with an accident, when can you claim the insurance? It's only when you show that, yes, I was following all the traffic norms, I was not going against the traffic rules. So in spite of that, there was a inevitable accident to which I'm going to claim my insurance. Only then insurance will be processed. But if you are drunk, if you're driving your vehicle, the first thing is that you are violating the traffic rules. That is why insurance will not be processed. Drunken drive. So for this reason, so the abiding with the rules and regulations is the primary factor. Let me just give you a small real-time case, okay, which happened about the forensics investigation regarding the fire. It's a English case law where this guy happens to buy an insurance for a particular product against the fire. It was a fire insurance. And what was the product? The product was imported cigar. Bada bada cigar jo aata hai na? For imported cigar, this guy happens to buy a fire insurance. Fine, the insurance company also have given the insurance policy for this particular product. And he, bindas, took all the cigars, he enjoyed the cigar, and he filed a insurance claim that because of the fire, the goods are burnt. Now process the insurance. So insurance company has not realized about this particular claim so far, and they happen to contest this before the court. This case went on to the Supreme Court of their respective country, and before the Supreme Court, in spite of the company arguing, saying that no, company would have given the policy by error, so we will not process this application for the claim. The court held it is a conclusive proof once the policy is issued. That means you are supposed to be validating the particular claim. So this particular product, Bindas, covers the fire claim. So the insurance company was supposed to be making the payment. The claimant was so happy, and it's a smart guy. Okay, so how many of you think this guy was so smart in exploiting the provisions which were mentioned in the insurance? And how many of you think this guy was smart? Let me know. Do you think this guy was very smart in claiming the insurance? But when we discuss about the smartness, this is where the legal professionals come to a picture. See, in law, nobody is smart. Okay, and if you ask me, everybody can be smart. It's only the question about application of mind which actually wins your case. It's not about any other thing. You know law, everybody are equal lawyers. Everybody has studied LLB. But what actually makes you so special, so significant is that your application of mind at the proper time, the right decision, the right act, the right way you're going to act, and right purpose you're going to achieve. So in this case, yes, in spite of the legal panel of experts, advocates who argued for the insurance company, they could not stop the insurance being paid to the insurer, whereas the company happened to pay multi-million dollars as a insurance claim. The insurer, the person who took the cigar, was Bindas very happy. Immediately, he was arrested for the reason the insurance company filed a case for arson. Arson is intentional fire. Yes, the cigar was insured for the fire, no doubt. But because you have intentionally lit the cigar, that actually comes under arson. So that's a criminal activity. So if for that, there is no insurance claim. So like this, they won the case back, matlab they punished the person, and they also took back that insurance claim which was issued. So this was just a significance of how the application of mind, in spite of the smarter people outside, you require to have the understanding about the technical as well as legal. That gives you a combination of techno-legal speciality. Only then you can fight the cases today. Or if you only go with the law or the provisions of the law, you will not be so special in the upcoming years. Because the upcoming years, the investigation trend has changed. There are a lot of scope of scientific investigations. And if you also know, there are national level universities which are coming up for the purpose of forensic sciences. So for this reason, the importance of forensic investigation is to be clearly understood by every law professional. Now, this case was again about the fire claim. If you look at the godown, whole godown is burnt. And we were called to examine if there was any kind of short circuit, because the complainant claimed it is because of short circuit. After the examination, we conclude in this particular case that this is not a result of the short circuit, but it is a case of negligence. In sense, the chemicals which they had stored actually reacted. They did not follow the fire safety or the chemical safety standards for preserving those chemicals in their godown, which resulted in some leakage of the chemicals, resulted in happening a fire like this, and the loss of the goods were around a couple of crores. Okay, as far as the claim is concerned, but the investigation only revealed that it was not a case of short circuit, but it was a case of negligent fire. This is another case where it was a negligence by the house owner, okay, which actually resulted in the house being burnt. Okay, and these cases are significant for the insurance claims. Now let me touch upon the vehicle key examination cases. Again, this case, this requirement is again for the insurance industry. Whenever you take your vehicle out, is it necessary that you lock your vehicle properly and you safely park your vehicle so that the thief will not take your vehicle? In spite of locking the vehicles, today when the thieves will break open the lock and steal the vehicles, what happens if your key is also left in the same vehicle? So that shows your negligence. But these cases will come to forensic examination when there is a claim for the insurance that I left my vehicle in a parking lot. Somebody stole my vehicle. I had carefully locked my vehicle. So in such case, the insurance company will ask you to submit the vehicle key. Remember, if you have locked it, you should be having the vehicle key with you, right? I believe the vehicle is stolen, but key must be with you. Submit the vehicle key. Okay. So there are two instances. If I have the vehicle key with me only, the question will also be like, do you also have the second key with you? Because vehicles will usually have two keys. He will say, हाँ, मेरे पास दूसरा key भी है, घर में है. Then submit both the keys to us. So what happens here? Scenario number one: if there is a genuine, theft, the key will be with the person. He will submit both the keys. one used key, another unused key, or a partially rarely used key. So we will examine the vehicle key if it is used or unused. This is called tool mark examination. Okay, because whenever we use the key, there is going to be some friction marks, because there's always a metal interacting with the metal inside the lock and key. So this actually forms some kind of friction. Because of the friction, there'll be styration marks. And this marks, in combination with the quality of metal of the vehicle key, indicates whether if the key is used, if it is used, approximately for how long it's been used. So all these things can be understood. And for all those, you can have some key with you right now. So can you just confirm if somebody has a vehicle key right now with you? If you have the vehicle key with you, I would request, please broadcast the video and show the vehicle key on the screen, please. If somebody can quickly get some vehicle key. Any kind of vehicle key, two-wheeler, four-wheeler, whatever. Please show it on the screen. Are there anyone who is having the key? If not,
The lock, door locking key would be okay, because I don't have vehicle key.
door lock. Okay, you show me whatever key you have it. Rohit ji, please demonstrate the key. Okay, participants, focus on the video of Mr. Rohit. He's trying to show a key on the screen. Rohit, we are not able to see the key yet. Can you please show the metal part of it? Yes. Yeah, correct. Okay, so this metal, participants, if you closely observe at the edges, there is some kind of the shade of the key has been affected. In the middle, the key is with a kind of white shade, whereas at the edges, it is a bit kind of copper shade, a bit yellow shade. Rohit, am I correct?
Yes, sir.
This indicates the key has been used over a period of time. See, if I'm not wrong, Rohit, your vehicle is not less than 8 to 10 months of usage, regular usage. The vehicle key.
Yes, sir. I regularly use this.
So how long you have been using your vehicle?
3 years.
3 years.
But this key I am using from correct 1 year, past 1 year.
Past 1 year. Okay. See, this metal will indicate the usage of the key. So like this, when the person who negligently left the key in the vehicle, which resulted in the theft, when the insurance company asks you, "Arey baba, if you're not so negligent, then submit both the keys to us." Abhi ye kya karega? He'll go buy some fake keys in the market and give it to the insurance company. See, this is the key which I was using it. Because we will not have the lock with us, we cannot verify if this key belongs to the same lock or not. Okay, because even the company will not have the database of which lock and which key was used. They don't have the database. They might have at the manufacturing level, but the sales level will not get the data. So this is a challenge, the investigation. So fine, when we get the key, forensically what we examine the quality of the key, quality of the metal, and if the key is used or not. And in this particular case, if you observe the photograph of the key, I have taken the side view of the key. Okay, and you can see there are two metals which are soldered. Okay, you can see there are two different, like a sandwich. So this quality of the metal is only because of the inferior quality, which is not supplied by the genuine company. Because when we say about the company key, companies will definitely have its standards. Okay, and to maintain that standard, including the vehicle key will be made of single metal piece, not like this kind of sandwich. So in this case, such examination revealed that the vehicle key was not actually supplied by the company, and it is a duplicate key which the person has submitted for the false insurance claim. The vehicle fire is again has two different segments. Every vehicle will have its insurance. It's compulsory under Motor Vehicle Act that every vehicle should have a third-party insurance, which means because of your vehicle, if some damage happens to some third party, your vehicle insurance company will cover that loss. Which means, suppose if you're driving and suddenly you cause damage to a pet dog, who will treat the pet dog right now? Your company, your vehicle's insurance company will pay that insurance amount, okay, to that dog's treatment. It could be dog, it could be human being, it could be other vehicles damage, whatever. That is called third party damage. But when you have a lorry, which actually has its insurance, and lorry will contain some goods, and the goods will have, okay, a logistic coverage. The goods alone can have a separate insurance. Okay, so when this vehicle will catch the fire, that means there are two insurance at stake. One, the vehicle insurance. Second thing is the goods insurance. So to investigate and confirm what actually caused the fire to the goods, which also resulted in fire to the vehicle, was it the fire of the vehicle which impacted the goods, or the goods fire impacted the lorry? So there is a question. So here we have to ascertain the cause of the fire, whether the vehicle was having any technical mechanical defects resulting in the fire, or the goods were of such nature, okay, which caused the fire. Only then the insurance companies will process its insurance claims. So here again, the trend of investigation includes insurance claims. And this, what you can see, is the extra fittings to the vehicles. And it is not usually allowed any kind of extra fittings to your vehicles, if in case you want to cover that under the insurance. Because these days it's become a pleasure and a trend where both सारा extra fittings, LEDs हो सकता है, sound horns हो सकता है. So all these things will be attached as a luxury or a show off piece. But such attachments will actually not help you for the insurance claims. And in this case, the question was, it was a vehicle fire, vehicle got burned because of some short circuit. And the question was if the vehicle had any kind of extra fittings. And such extra fittings will cause the short circuit. Okay, so in this case, we actually proved that the vehicles had extra fitting, and that is when the insurance claim was not processed. The power has been taken for those extra fitting, which compromises the load of the electric of the particular vehicle, and it divides the electrical load, resulting in possible short circuits. Okay, so apart from this, what you can see on the screen is fake mark cards, which are going to be, there are good known, well organized rackets, which will create different fake certificates and different fake documents. We'll cover this during our second session, which is exclusively on document frauds, document evidences. But addition to this, what I want you to understand at this time is that the scope of the investigation. If you look at the screen right now, by reading the content on the screen, by looking at the document on the screen, do you find this document to be genuine, or do you find anything suspicious in this particular piece of document? Please comment. Participants, does anybody has any reason to suspect this particular document? No. Okay, so in such case, the document is dated in 1941, isn't it? So the 1941 document, everything is a perfect typewriter, typing is there. Okay, everything is fine. This case was brought to us for examination of the signature in this document. Examination of signature, that's again a signature examination. We discuss that later. But even without examining the signature, I found one good reason to content about this document because of the font used in this document. This font which is used here is called the Courier font. Font name is Courier. The Courier font was introduced only in 1956, but not in 1941. So this document, even if it is claiming to be in 1941, on that particular day, the Courier font itself was not there, and hence this document can be considered as a fraudulent document. And remember, including Imran Khan of Pakistan, no, not Imran Khan, Nawab Sharif. Nawab Sharif, whatever, he actually had submitted a fake document. Okay, and that particular document and the font which was used in that particular document was supposed to be Calibri, and the date of the document in which it was submitted in the international forum, on that particular date of the document, the Calibri font itself was not in practice. So in the documents, the font, the technology, everything will play a role if the document can be considered as genuine or fraudulent. Before I conclude my session of the first hour, the session is now open for discussions and clarifications. And in the second hour, we'll specifically discuss about the documentary evidences. Participants, any questions? You can ask me now.
Yes, students, if you have any questions, you may ask.
Any questions about forensics in the court of law? This topic is open for that discussion. Because second and third exclusively discuss about documentary and digital evidences. We'll take up those questions exclusively over there. But anything about forensics, you can ask me now.
So, I just have one small query.
Go ahead.
In spite of having this kind of conclusive proof that we can say actually through forensic, which is almost 99.99% at times are proper or very much conclusive, yet our court having advanced technology and everything, despite of this, we don't agree or accept this kinds of evidence. What could be the reason? It's the legislation which does not want to use this technology, or is there something else?
What I see is that the option of the discretion to the judge is good actually, because judge is not supposed to be acting only on the basis of the technical opinion, because technical opinion will also be supported by sound and logical reasonings. As far as those reports support that sound and logical reasoning, the judge will definitely consider such kind of opinions. But the specific question which you asked me, we are still following the Evidence Act, which is enacted in 1872. We are in 2022. The act which we are adopting to ourselves is of 1872. But yes, there are few amendments which are made, but still a lot of provisions which doesn't even fit for present days technology or present days requirement. By the time the lawmakers realize that there is a need, and by the time they change that particular practice, on that particular day, the technology is affected, technology is improvised, technology is changed. So to come back to that day's technology, so this is where one of the sources for the law is the judgments. Judgments are passed on the basis of today's case, today's trend. Okay, one of the sources of law is the enactments, legislative, the bills what they pass, that becomes an act. But one important source of law is your judgments. When the judge discusses this case today before the Supreme Court, judge will consider today's aspects. Okay, that is when the law becomes the source of law becomes a judgment also.
Thank you, sir.
There is one message on the chat box which says, what is the time frame for collecting the evidence? Evidences are of different nature. The evidences can be classified as physical evidence, physical evidence, impression evidence, digital evidence, biological evidence, psychological evidence. Okay, so like this, different evidences has different time frame for collection, but earlier is the best, is a simple policy. Whichever, how much ever fast you can get hold of the evidence and secure it, that is where the evidence can have some value. Just like in Arushi's case, for example, the blood samples were collected after 16 to 18 days of exposure to the direct sunlight. Okay, the blood samples were on the terrace. It was exposed. By the time the forensic team came to the scene and took the blood samples, it was almost late. Okay, so effective technical examination in that case could not be conducted. So due to the limitation in the examination of the evidences. So earlier is the best. That's the only principle. Anything else? No. So in such case, we can.
So I hope there are no questions. So thank you for sparing your valuable time, sir, and see you next session at 1:30. Okay.
Sure. Yeah.
Yes. So I would like to request all the students again to join at 1:30 sharp, and the next session will be on the documentary evidence and the legalities in the documentary evidence. Okay. So see you in the next session. Thank you.
Yeah.